This is the revision series on Indian polity, and today we are dealing with 11th chapter, that is Basic Structure Doctrine. In this video we will understand how basic structure doctrine emerged in India, how various judgments led to emergence of basic structure doctrine, and what features constitute basic structure. We will understand whether fundamental rights are amendable or not, and cases regarding that. So let us begin. How basic structure doctrine emerged in India. See, initial view of the parliament was that it can amend everything. So parliament was doing that. It started with the First Amendment Act 1951, followed by the Fourth Amendment Act 1952. With these amendments, government brought socio-economic reforms. Socio-economic reforms such as reservation to backward communities, land reforms, acquisition of private property of individuals for national purpose, etc. But this violated the fundamental rights of individuals. And what does the Article 13 says? It says that if any law is violating fundamental rights, it shall be void. So Parliament cannot take away fundamental rights as such. But it was important to implement those reforms in national interest because those were the socio-economic reforms. Mostly. This led to conflict between fundamental rights and power of parliament to make those laws. Indirectly, this led to conflict between Supreme Court. Supreme Court was guarantor of fundamental rights and the parliament. The parliament had power to implement those laws. So the debate was regarding this, whether the fundamental rights are amendable or not. Can parliament amend the fundamental rights to give effect to other provisions even for national interest? So this takes us to Shankari Prasad case of 1951. In the Shankari Prasad case of 1951, Supreme Court held that the Parliament cannot take away any fundamental rights. Supreme Court said, see, if a law is altering fundamental rights, it is changing fundamental right, then it shall not be valid. But amendment is a special power of Parliament, and amendment is not ordinary law. Therefore, even if law cannot change fundamental rights, but amendment being a special provision can change fundamental rights. So Shankari Prasad case of 1951 allowed fundamental rights to be changed by Parliament. But fast forward to 1967, the Golaknath versus State of Punjab case, the validity of the first, fourth and seventh constitutional amendment was challenged. In this case, the Supreme Court reversed its previous ruling and declared that the power to amend the constitution and legislative power of parliament were one and the same. There was no any special amendment power. Therefore, any constitutional amendment should be considered as a law under Article 13. That is, law includes amendment also. And law cannot violate fundamental rights, and hence even amendment cannot violate fundamental right. So amendment acts under Article 368 cannot amend fundamental rights as it would violate Article 13. That means the fundamental rights cannot be amended even for the implementation of directive principles for national interest. In other words, the Golaknath case limited the power of Parliament to amend the Constitution under Article 368. This was set back for Parliament. The Golaknath judgment hindered the government's effort to enact social and economic reforms through legislation such as the Private Purse Abolition Act, Bank Nationalization Act. In response, the government passed the 24th and 25th Constitutional Amendment Acts in 1971, amending Article 13 and 368 itself. So what was provided in these 24th and 25th Constitutional Amendment Acts? Let us discuss. The 24th Amendment Act stated that any amendment act passed under Article 368 would not be considered as a law under Article 13. So, preventing it from being invalidated under Article 13. Because under Article 13, any law, if it violates fundamental rights, shall be void. Additionally, the amendment introduced a provision stating that the validity of Constitutional Amendment Act cannot be challenged on the grounds that it takes away or affects fundamental right as stated in Article 368 Clause 3. That means there shall be no judicial review of law affecting fundamental rights. Hence, if any amendment is made under Article 368, it shall not be challenged in court of law. 25th Constitutional Amendment Act 1971 inserted Article 31C, which implied that directive principles under Article 39 Clause B and Clause C are more important than Article 14 and 19. Article 39B and C were directive principles related to socio-economic reforms, and Article 14 and 19 were related to fundamental rights. And with this act, directive principles under Article 39 Clause B and Clause C were given more priority than some fundamental rights under Article 14 and 19, for example. And laws implementing such directives shall not be questioned in court of law. So, it blocked the judicial review of such law. How? By putting Article 31C in Schedule 9. Schedule 9 is the iron box. Initial view of the Parliament was that if you put anything under Schedule 9, it is automatically immune from judicial review of the Constitution. Supreme Court sensed that it was not right. It is not healthy for democracy. It saw that fundamental rights are in danger and state can make anything that can change fundamental rights. Then came the MyBap of all cases in India, the Keswanand Bharti case. Keswanand Bharti case of 1973. Keswanand Bharti vs. State of Kerala case 1973 challenged the constitutional validity of the 24th, 25th and 29th amendments. The court ruled that while the Parliament has the power to amend any provision of the Constitution, it must not tamper with the basic structure of the Constitution. First time basic structure doctrine was propagated. See, here Supreme Court took a mature view. It acknowledged the power of Parliament to amend the Constitution, but in case of arbitrary legislation, it also put a limit on the Parliament's power of amending Constitution. The court found that 24th Amendment Act to be constitutionally valid, and for the 25th Amendment Act, the first clause was deemed valid. That means you can give preference to DPSPs under Article 39 Clause B and Clause C over fundamental rights. But the second clause, which abolished the judicial review of power of court, that clause was invalidated as judicial review is considered a basic feature of the Constitution. It forms the basic structure of the Constitution. So even if that law is under Article 31C, it is subjected to judicial review. Also, the court overruled the Golaknath judgment, which earlier stated that Parliament cannot take away fundamental rights. It was stated in 1967. And then came the basic structure doctrine, asserting that the Parliament could amend the Constitution, but only within the limits of the basic structure. Parliament सब कुछ amend कर सकता है, but Constitution का basic structure change नहीं कर सकता. And that means Supreme Court decided to reverse its earlier judgment made in Golaknath with some changes. Now let us understand ये basic structure doctrine exactly होता क्या है. What constitutes a basic structure doctrine? See, even if basic structure doctrine was introduced by Keswanand Bharti case, it was not defined by that case. Supreme Court, through its power of judicial review and through various judgments, has expanded the scope of basic structure and included these aspects as basic structures such as the supremacy of the Constitution, the sovereign and republican and democratic nature of Indian polity, the secular character of the Constitution, the separation of power between legislature, executive and judiciary, that is between the three organs of the government, the federal character of the Constitution, the welfare state, effective access to justice, unity and integrity of India, rule of law, free and fair election, the principle of equality, the principle underlying fundamental rights and harmony and balance between fundamental rights and directive principles of state policy, parliamentary system, power of Parliament to amend Constitution, the judicial review of the Supreme Court and even High Court, and etc. So this is more of a factual data, but glance through this from the book and revise. Also solve some questions on this chapter, because questions are asked in the nature. You will be asked to find which among the following feature is part of basic structure of Indian Constitution. So you should know that, and to know that, Read this chapter from book and revise from here. So this is it from this chapter. This was 11th chapter. I hope this revision series is helping you in quick revision. To get these notes in PDF format, visit indiashastra.com, and link to this series is pinned below in comment section, or you can find that in description box. So thanks for watching and have a good day.